In this lecture, we shall discuss rule of law. We shall discuss rule of law. More specifically, we shall discuss the theoretical basis of the rule of law. Over here, we shall look at how the scholars have explained the whole idea and the concept of rule of law. The reason this is important is because the whole concept of rule of law is one that has been regularly used by lawyers, politicians, students of the law, without necessarily offering any explanation as to what the rule of law is. So in order to make the point very, very clear, we have to go through what the various theorists have said about the rule of law. We shall look at the Western liberalism standpoint of the rule of law. We shall look at all the theorists. We shall look at Lord Fuller on what he says about the rule of law. We shall also examine what Joseph Ras says about the rule of law. Then we shall also examine what A.V. Dicey says about the rule of law. We'll look at how contemporary scholars have addressed the rule of law. We'll examine the exposition of the rule of law by Sir Kofi Komado in his book, A Handbook of the Constitutional Law of Ghana and its History, how the learned author also conducts an exposition of the rule of law in his book. Now, by the time we go through all of these theorists, and we are able to examine the concept of the rule of law from the theoretical standpoint of all of these theories, any doubt we have in our mind as far as what the rule of law is supposed to have been cleared. Now, when we do that in this lecture, then we can now proceed to look at how the concept has been applied in certain jurisdictions, including the Republic of Ghana. So for purpose of this lecture, we shall be discussing the theoretical exposition of the concept of rule of law so that we can understand what the whole idea of the rule of law is. Now, to start with, it is important to set the ball rolling by making it very, very clear that in contemporary times, when we say rule of law, the expression rule of law in contemporary times can be used in two main senses. The first sense, which is the formal sense, is one that places emphasis on what the law is, what has been written down. That is what will be described as the rule of law. So, for example, if in the country there's a law that says that all persons should drive only between the hours of 3 a.m. and 5 a.m., that is what the law of the country says. So, in the formal sense, that is the rule of law. But you realize that in the formal sense, the more emphasis is just placed on what the law is. And little attention is given to the quality of law, the extent to which the law seeks to promote the good of society. So in the formal sense, rule of law basically would refer to only the law that has been written down, or what we can call the substantive laws of the state, and no attention whatsoever is given to the quality of the law. But in the second sense, rule of law may be concerned more about the quality of the law. It may be more concerned about how good the law is. It may be more concerned about how the law is meeting the needs of society. And so, in the second sense, the rule of law concept is rather more inclined towards looking at certain values that the law should respect in order to advance a just and a free society. And so, to drum home the point clearly, that when we use the expression rule of law, it can be used in contemporary times in those two senses. I shall refer you to some notable authorities. But before we even delve into that, if you look at these first two senses that we have looked at, the rule of law can only refer to the substantive law in the first sense, and in the second sense, which can be the broader sense, it is referring to the quality of law. You remember the days when we have and we experience the days of Nazism or even apartheid, or even in authoritarian regimes. You can have a law that is saying that all people that have this particular feature should be killed or should be beaten to death. And that can be a substantive law of the state. Now, does that law, the presence of that law, mean that it is advancing rule of law? The answer will be no. In other words, the mere fact that we have law in itself doesn't necessarily mean that we have a rule of law. So in the first sense, we focus more on just the substantive law. But in the broad and what is the more dominant sense, when we say rule of law, it is referring to the quality of law. So as we proceed, you will see that the scholars try to draw a distinction between law merely as it is on the law books and the quality of law. And it is the second sense which is the more dominant approach in explaining what rule of law is. So I shall begin first by quoting from the book authored by Sir Kofi Kumadu. And this book is titled A Handbook of the Constitutional Law of Ghana and Its History. And I shall start quoting from page 19 of this book. And this is what the learned author says. To understand, and I quote, to understand the concept, we note the two uses of the expression rule of law in contemporary discourse. The first is in a formal sense, where we might say, for example, that an offer and acceptance constitutes a valid contract. This is a well-known rule of contract law. It is a proposition or principle which we are confronted with early in our study of contract law in law school. But the statement tells us nothing about the quality of law so stated. No society can survive without such rules of law. Second, there is the ideological use of the expression. This usage draws our attention to the quality of the so-called rules of law. It provides us with a yardstick or ideas for measuring good or bad law. It enables us to separate a constitutional regime from an oppressive or authoritarian one. Thus, if we say a society is based on the rule of law, we do not simply mean that that society is governed by law in the formal sense. Though the existence of laws is an important starting point, it is not just about the existence of enacted laws. As noted above, when properly understood, the expression provides us with ideas for demarcating the boundary between good and bad law, between a good governance system and a bad one, between a totalitarian geographical space and one in which political freedoms reign or prevail. And the quote ends. So what is the learned author saying in his book? That in every legal regime, you will have rules of law. You will definitely have substantive laws of the particular states. But the mere fact that you have the rules of law, the substantive laws, the laws in the statute books, the laws in the books, the laws in the company's code, whatever it is, the mere fact that you have those rules of law doesn't necessarily mean that there is rule of law in that particular system. Because the contemporary use of the expression rule of law does not have its main focus on the law as you have in just the law book. It has more attention towards the nature and the quality of the law. It is more focused towards how to distinguish which law is good and which law is bad. So rule of law in the dominant sense and the popular sense refers to the guiding principles and the characteristics that will help us identify when we can have a law that we can describe as a good law. This is what we can get from Sir Kofi Komado's book titled A Handbook of the Constitutional Law of Ghana and its History, specifically at pages 19 and 20 of his book. Now, let me also refer you to a very important statement made on rule of law by Hilaire Barnett. Hilaire is spelled Hilaire, Barnett, in the book titled Understanding Public Law. And this is what the learned author says at page 36 of the book. There's a portion headed Western Liberalism. And this is what the learned author says about the rule of law over there. And I quote, in Western liberal democratic societies, it is generally assumed that the rule of law is a force for good. It is law that controls the power of the state and law that protects the rights and freedoms of citizens. However, the rule of law is a concept far wider than the law. In a democratic society where government is dependent ultimately on the will of the people to retain its power, the law will in general be benevolent. In non-democratic societies or societies that are ruled by a harsh regime, the law may be far from benevolent. As Nazi Germany so starkly showed in the 20th century, and until more recently, the South African regime with its discriminatory system of apartheid. So law of itself is not necessarily consistent with the rule of law. I'll take that portion again. So law of itself is not necessarily consistent with the rule of law. The rule of law implies certain values that the law should respect. And I shall end the quote over there. So you realize that what Hilaire Barnett is also saying is that the rule of law implies certain values that the law should respect. So it's not about the mere presence of the law in the law book. Because in Nazi Germany, we could see laws that were arbitrary, that were being used to violate people's fundamental human rights. Now, the mere fact that those activities were carried out in pursuance of laws written in the law book does not necessarily mean that it was in furtherance of the rule of law. As we have seen from Sir Kofi Komado's book and Hilaire Barnett, we've seen all of them saying that the rule of law implies certain values that the law should respect, so that we can now determine which law is a good law and which law is a bad law. We also have Lon Fuller. Lon is spelled L-O-N Fuller. He was a professor. So Professor Lon Fuller of Harvard University. In his literary work, The Morality of Law, Fuller provides a different perspective on the rule of law. Now, Fuller's position was more inclined towards the role of law and the relationship it had with its citizens. So, according to Lon Fuller, there is a very essential moral quality in law, that if you pass a law, there must be some moral qualities in that particular law. And that in every legal system, there must be some basic requirements of that particular legal system. And Fuller identifies that some of the basic requirements of the legal system are that laws must operate prospectively and not retrospectively. That the law must be clear and relatively certain. That the law must be publicized and must not be kept in secrets. That laws must be non-contradictory. That there must be an accessible court system. And that the court system must be staffed by independent judges. So Fuller has identified that in every legal system, these must form the basic requirements of that particular legal system. Remember, we are talking about advancing the rule of law. That if you have laws, the law should operate prospectively. They should operate from when they were passed. And the law should not go back and then operate retrospectively. The law must be clear and must be relatively certain. The law must be publicized and not kept secret. The law must be non-contradictory. There must be an accessible court system, and the court system must be staffed by independent judges. And this is Professor Lon Fuller of Harvard University in his literary work, The Morality of Law. So Fuller then adds that in addition to all these requirements, that there is a morality of aspiration. And this morality of aspiration is that in every legal system, the law must allow the citizens to pursue their legitimate goals. And according to Fuller, if it is a legal system that fails to allow the citizens to pursue their legitimate goals, then that law lacks an essential defining quality, that of morality. So Fuller has basically told us that if you want to identify what the rule of law is, we should look at how the law relates to the citizens, and that the law should play a guiding role in how it can guide people to set a framework as far as pursuing their legitimate goals in life is concerned, and that the law must be there to facilitate and serve the people. And so he goes ahead to give us some basic requirements that must exist in the legal system. Professor Lon Fuller of Harvard University, in his literary work, The Morality of Law. Then we have another professor, Joseph Ras. Professor Joseph Ras, he was of the University of Oxford. And he also has a literary work titled The Rule of Law and Its Virtue. The Rule of Law and Its Virtue. Now, Professor Ras took note of the requirements that had been mentioned by Fuller that must exist in the legal system. That is the basic requirements that have been mentioned by Lord Fuller. You remember those requirements, that the law must operate prospectively and not retrospectively. The law must be clear and relatively certain. The law must be publicized and not secret. The laws must be non-contradictory. There must be an accessible court system, and it must be established by judges. So, you remember these were requirements of a legal system that were underscored by Lon Fuller of Harvard University in his literary work, The Morality of Law. So now we have Professor Joseph Ras. Ras is R-A-Z, who was of the University of Oxford. So he noted all these requirements that had been mentioned by Fuller, and then he even, while approving them, he then adds more. So Ras has now added to the requirements of a legal system that were postulated by Lord Fuller. So Ras adds that these requirements must also be added. The requirement that the independence of the judiciary must be guaranteed. The requirement that the principles of natural justice must be observed. And also that the discretion of crime-preventing agencies should not be allowed to pervert the law. The discretion of crime-preventing agencies should not be allowed to pervert the law. So we've noted that Professor Ras adopted those minimum requirements of the legal system that were mentioned by Fuller, and he has even added to them. But there's an interesting point, because Joseph Ras rejects Fuller's view that's related to the moral nature of law and the link between law and morals. So according to Joseph Ras, and remember we are talking about Professor Joseph Ras of Oxford University in his literary work, The Rule of Law and Its Virtue. According to Joseph Ras, it is very possible that you can have a law which does not have any morality embedded in it, but that law and that regime will be perfectly in compliance with the rule of law. Be perfectly in compliance with the rule of law. So even though Professor Ras accepted the minimum yardsticks of a legal system that were given by Fuller, Ras only was rejecting the view that was given by Fuller, that there must always be a morality of the law. According to Professor Ras, you can have a morally repugnant regime, and that regime would still be in compliance with the rule of law. But it is important to note that this view that was taken by Professor Rass was also kicked against by Hart. Hart was saying that, hey, if you have a regime that is an evil regime, that does not have any morality, it is possible that that regime would be violating the basic principles of rule of law, so that they would then violate the consent principles, the cardinal principles of the rule of law. And that the evil regime can go ahead and even enact secret laws, and that they can go ahead and enact retrospective laws and even contradictory laws. So even though Professor Rass was taken against the inner morality of the law, even though Professor Rass was saying that rule of law doesn't necessarily mean that there must be an inner morality of the law, Hart has also taken against what Professor Rass has said. And Hart is saying that he thinks that, well, there must always be that morality of the law. Now you can see that in the midst of these different standpoints of the theorists, in the midst of these different standpoints from Lord Fuller, from Joseph Rass and Hart, they are all in common agreement that in every legal system, if we say there's rule of law, there must be some minimum yardsticks and guidelines that must be present. That there must be the independence of the judiciary, that the principles of natural justice must be observed, that the discretion of crime-preventing agencies should not be allowed to pervert the law, that the law must operate prospectively and not retrospectively, that the law must be clear and relatively certain, that the law must be published and not secret, that laws must be non-contradictory, that there must be an accessible court system, and the court system must be staffed by independent judges. So have your mind on the goal that there is some common agreement, at least from all the scholars who have propounded their respective standpoints about the rule of law. And even when you read Sir Kofi Kumado's book, titled A Handbook of the Constitutional Law of Ghana and His History, you realize that the learned author even sums up these components or ideas or virtues or elements of the rule of law. He tries to sum them up, and he is able to identify about 14 of these various elements of the rule of law. And so in order to give you confidence that you understand the concept of the rule of law, I would reproduce and quote in extenso these 14 virtues or elements or ideas that Sir Kofi Kumado identifies that underpin the rule of law. And you will see this on pages 20, 21, and 22 of Sir Kofi Kumado's book titled A Handbook of the Constitutional Law of Ghana and Its History. And this is what the learned author says from page 20, and I quote: as a dynamic governance concept, then, the rule of law embodies the following ideas, elements, or virtues. 1. Eradication or absence of arbitrariness or uncontrolled discretion in the exercise of governmental power and the conduct of government business in a society. 2. The subordination of government action to rules or laws which secure the dignity and liberty of the individual, rather than the whims and caprices of the governors, and excuse the arrogant use and conception of public power. 3. Elimination of inequalities in society as much as possible. Where the inequalities relate to status or functions or involve immunities and privileges, there should be transparency about them. 4, respect for rights. In constitutionalism, rights are perceived as means for taming government, not ends in themselves generally. But in rule of law, they are presented as ends as well as means. 5, the existence of effective remedies which are accessible to all levels of society and are available against all violations of interests. 6, the existence of independent, free, impartial, and incorruptible judges and judicial system. 7, independent and courageous bar, where the lawyers ensure that everyone accused of wrongdoing has his day in court, is duly represented, and has access to affordable justice. 8, these are intertwined and inherently linked. For if an independent judiciary is the backbone of the rule of law, then an independent and courageous bar is the catalyst that protects and helps to achieve it. 9, it entails a fair and public trial. This means adjudication of disputes by regular and permanent courts rather than special and ad hoc tribunals. Special tribunals, where they are thought to be necessary, should be kept to the minimum, and their decisional mechanisms should measure up to the standards of normal and acceptable judicial behavior. Their decisions should be reviewable by the regular courts. 10, there must be open hearings of court proceedings to which the public have access, and there should be effective supervisory systems to ensure that courts remain faithful and serve only the laws and not the wills of the powers that be. 11, there must be an efficient, incorruptible, and effective police system coupled with the subordination of law enforcement agencies to the law and civilian control. 12, the rule of law requires that the rules must precede actions, and therefore not only must their definitions be clear and certain, but we must eschew retrospectivity, especially retrospective penal legislation. This certainty will make the law predictable and inform the citizenry of the potential consequences of any proposed course of action. 13, there must be judicial review of legislation and judicial control of the administration to ensure lawmaking and executive action will be accountable to the generality of the citizenry. And 14, an important institution for the flourishing of the rule of law is an independent, free, and responsible media, which provide a robust platform for the dissemination of information to the public and hold government accountable to the people. So you can see, at this point, now we have finished quoting the 14 elements or virtues or ideas that, according to Professor Kumado, embody the concept of the rule of law. So you can see that this is more like an aggregation of all the respective elements that have been identified by Professor Brass, Professor Fuller, Hart, and all the scholars that have spoken so far about the rule of law. But there's one scholar that we cannot discuss rule of law without mentioning his name. As a matter of fact, this scholar is the one who has even been credited with the coining of the expression rule of law. And he is the English constitutional lawyer, Albert Venn Dicey. Venn is spelled V-E-N-N. So people just shorten this A.V. Dicey for short. And he did this exposition in a seminal work, which is titled Introduction to the Study of the Constitution. Introduction to the Study of the Constitution. Introduction to the Law of the Constitution. That is A.V. Dicey. And in his work, which has had considerable influence on many scholars ever since, Dicey identifies three meanings that can be ascribed to the concept of the rule of law. Three meanings. Three meanings. Number one, Dicey says that no one should be punished other than for a distinct breach of the law. So his express words are that no man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts. These are the words of A.V. Dicey. The first element A.V. Dicey identified is that no man is punishable or can be lawfully be made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the courts. So that's the first element identified by A.V. Dicey, that no one should be punished other than for a distinct breach of the law. And then the second element identified by A.V. Dicey is that irrespective of the status of people in society, all persons should be equal before the law. And then thirdly, A.V. Dicey gives an indication that there must be the effective protection of human rights. There must be the effective protection of human rights. So let us take each of them one after the other and see how best we can deal with them. The first part that says that first, no man is punishable or can be lawfully be made to suffer in body or goods, except for a distinct breach of law established in the ordinary legal manner before the ordinary courts. So what Dicey is over here saying is that there must be a distinct law that a person must have breached before that person must be punished. So the law must be clear, the law must be certain so that it can offer real guidance to the citizenry of what they will do, that they know that if they do this, they'll be held to have breached the law that they are going to be punished for. In other words, Dicey is objecting to wide discretionary powers, which can lead to arbitrariness. So, for example, if there's a law that says that a police officer has the power to arrest anybody at all, that the police officer, in his own estimation, thinks the person might have committed a crime. Imagine a law like that, that says that the police have the power to arrest anyone that they think might have committed a crime. It means that anytime the police officer wants to arrest anybody, he sees you by the road, he just picks you up and arrests you. And you yourself, you will not even know what you have done wrong that you have been arrested for. So Dicey is trying to kick against this wide discretionary power that can subject people to any form of abuse of such discretionary power. And the people will not know what wrong they have committed, for which reason they are being subjected to such treatments. That's why in Dicey's first element, he says that no one should be punished unless there is a distinct breach of the law. His express words are that no man is punishable or can be lawfully be made to suffer in body or goods, except for a distinct breach of the law established in the ordinary legal manner before the courts. So Dicey is kicking against wide discretionary power, which might lead to arbitrary use of power and abuse of people's rights. But let me just mention that I'm not saying that in the legal system there can be no discretionary power. But the discretionary power should not be so wide such that it can be abused. And even when the law gives you the discretion to exercise some power, that discretion must be exercised in a manner that is supposed to be fair. So that if you go and exercise your discretion in a manner which is arbitrary, then the law will say that the exercise of that discretion will be deemed to be arbitrary and therefore unlawful and contrary to the rule of law. I'm not saying that the law cannot allow people to exercise their discretion. Even when the law gives you the power to exercise the discretion, it must be fair and in accordance with law. Other than that, we hold that it is contrary to the rule of law. Now, even though I do not intend to go into the cases over here, let me just for this purpose refer you to the case of Sagnata. Sagnata is spelled S-A-G-N-A-T-A. Sagnata Investments versus Norwich Corporation. Norwich is spelled N-O-R-W-I-C-H. Norwich Corporation. And this is reported in 1971 to Queen's Bench at page 614. In this case, the local authority was given the power to grant licenses for amusement arcades. The local authority was granted the power to grant licenses for amusement arcades. However, this local authority went ahead to adopt a policy that it would never go ahead and grant any of the licenses at all, regardless of the merit of the application. Let's look at this. The law has given you the power to grant licenses for amusement arcades. Then you have gone ahead to exercise your discretion to adopt a policy that you would never grant any of the licenses, irrespective of the merit of the application. The court ruled that this is unlawful and that the authority had fettered its discretion by adopting a very rigid policy. So this is going back to enforce Dicey's first position, that no man should be punished or lawfully be made to suffer except for a distinct breach of the law established in the ordinary legal manner before the ordinary courts. Meaning that we must always be able to point to the law before you say that somebody has violated it or not. We are trying to take away discretionary power. The law should be there so that we know what the law is saying. And in order to achieve Dicey's first position too, that no one should be punished unless for a distinct wrong, it means that the law should also be prospective and not retrospective. Because if the law is retrospective, it means that at the time the person committed the act, there was no law that was making it criminal, but you're going to now make it criminal. So we don't want to do that. So law should be prospective. If you pass a law today, the law should take effect from today into the future. You can't pass a law today and say that it should go back into history and punish somebody for it. So that is also one way we can achieve Dicey's first exposition, that no one should be punished for any wrong unless it is for a distinct breach of the law. So laws have to be prospective and not retrospective. So on Dicey's first requirements, we can explain it in line of discretionary power, and also that laws are supposed to be prospective and not retrospective. In order to explain this requirement that the law must be prospective and not retrospective, let me bring the explanation out clearly with the case of R versus R, which is reported in 1992, three weekly law reports at page 767. This case presents a very interesting scenario because the husband in this case was prosecuted for raping his wife. But you see, at the time that the husband committed this alleged offense, there was a legal immunity from liability which prevented husbands from being charged for rape in relation to their wives. This is because at the time, the law was that once a husband and a wife marries, they were united, they become one flesh, and that the wife has consented to sexual intercourse throughout the marriage. And so if the husband goes ahead to have sexual intercourse with her, she's deemed to have already given her consent by virtue of entering into the marriage with her husband. But when the case came before the courts, the House of Lords abolished this immunity and nonetheless held the husband liable for rape. So think about it. At the time the husband committed the act, there was a law that was supposed to give him immunity. But you've gone ahead to inflict punishment on him, even though there was a law in force that was supposed to give him immunity. You abolished the immunity and held him liable for rape. The husband took steps to go to the European Court of Human Rights, arguing that the English court had violated that principle of non-retrospectivity because at the time he engaged in the act, the thing was lawful. Now he has come to the court and you have repealed that immunity and you have imposed punishment on him. So he went to the European Court of Human Rights. But still, the European Court of Human Rights upheld the House of Lords decision. And accordingly, the husband was convicted and punished accordingly. He was punished for conduct that was thought to be lawful at the time he engaged in it, but it became unlawful subsequently. So you see, this is a problem. I have a problem with this because at the time he engaged in an act, the law was perfectly legal. Then you go ahead and now when the matter has come before the court, you repeal the immunity and you will go back in history and then punish him for what was not an offense at the time that he committed it. This principle against retrospective criminal legislation is what even in the Republic of Ghana, we have even provided for under Article 19, Clause 5 of our 1992 Constitution, which reads that a person shall not be charged with or held to be guilty of a criminal offense which is found that on an act or omission that did not at the time it took place constitute an offense. If it did not constitute an offense at the time it took place, why do you go ahead and punish a person for it? But anyway, that is what we can say about the first element of Dicey's exposition of the rule of law. That before a person is going to be punished for a law, there must be a distinct breach of the law. And this means that we are condemning wide discretionary power, we are condemning retrospective legislation. And that the law too must be very, very what? Clear. Now, if that says the law must be clear, it means that the law must be clear so that I will know that this is what the law is. And that if I breach it, then I'm going to be punished for it. So within Dicey's first element, we can have these three things over there. That we are condemning wide discretionary power, we are condemning retrospective legislation, and we are going in favor of the law being very, very clear. And in relation to this requirement that the law must be clear, look at Article 106 plus 11 of the 1992 Constitution of Ghana, for example. It says that no bill shall become law unless the bill has been published, has been duly passed, and has also been what? Published in the Gazette. Meaning that it must be published in the Gazette for the people of Ghana to see it before the law will be deemed to have been passed to even have an effect. So Article 106 clause 11 reads as follows, and I quote, without prejudice to the power of Parliament to postpone the operation of a law, a bill shall not become law until it has been duly passed and assented to in accordance with the provisions of this Constitution, and shall not come into force unless it has been published in the Gazette. So you see, when Dicey says that no person shall be punished unless for a distinct breach of the law, distinct breach of the law means that the law must be clear over there for us to see. And that is what we have also provided over here under Article 106 clause 11. And you can even see a similar thing under Article 19 clause 11 of the Constitution. 19 clause 11 of the 1992 Constitution of Ghana reads as follows: no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in the written law. See, this aligns with Dicey's exposition that no person is supposed to be punished unless it is for a distinct breach of the law. Now let us move on to Dicey's second requirement or element of the rule of law. Dicey mentioned that regardless of social status, all persons must be equal before the laws of the land and must be subject to the ordinary law courts. Now, this principle is very important because it has been abused in different settings. Some people think that because Dicey says that then there must be equality before the law, then it means that everybody at all is supposed to be equal, but that cannot be the case. Now, what this principle essentially explains is not that every person at all, regardless of whoever you are, should be given and treated equally. That will rather yield to unjust consequences. What this rather means is that like situations should be treated in a like manner. So let's say students should be given equal treatment. Pastors should be given equal treatment. Soldiers should be given equal treatment. But you can't say a soldier and a student should be given the same kind of treatment. That will not be fair. And on this point, let me read out the words of Hilaire Barnett in their book titled Understanding Public Law to let you know how they explain this equality before the law. And I'm quoting from page 44 of the book. And I quote, equality before the law. This aspect of Dicey's analysis of the rule of law causes problems and is often misinterpreted. The principle of equality before the law does not mean that each and every individual in society should have equal powers, rights, freedoms, or obligations. It is an important principle of justice that like situations be treated alike and that different situations are treated differently. To treat all in exactly the same way, irrespective of different capacities, characteristics, needs, etc., would be arbitrary and itself contrary to the rule of law. Accordingly, it is necessary to make adjustments to ensure that different factors are dealt with differently. It would be wrong, for example, for the law to treat a child of 7 in exactly the same way as an adult in relation to criminal liability. Equally, it would be wrong to treat a mentally ill person as having the same legal capacity as a person without a mental illness. The law must also make provision for different treatment towards those who are physically disabled. To act justly is to treat like cases alike and to treat different cases differently, taking relevant differences into account and make adjustments for them. Quote ends. And on this, in our next lecture, we will examine a number of cases, including the Ghanaian case of Nate versus Gatti, reported in 2010, Supreme Court of Ghana Law Report at page 745. But that is for equality before the law. And then also, Dicey argues that there must be the effective protection of human rights in order to advance the rule of law. So in Ghana, for example, we have a full chapter of our constitution from Articles 12 to Article 33 devoted to fundamental human rights. So Dicey is arguing that there must be the effective protection of human rights and the legal remedies to protect such human rights in order to advance the rule of law. And these are the elements given by A.V. Dicey in his book, Introduction to the Law of the Constitution. So let me just mention that A.V. Dicey's exposition has been criticized by a number of people, but it largely still remains the guiding principles in identifying what the formulation of the rule of law, what the rule of law is. For example, you can look at Friedman. Friedman has also reformulated what A.V. Dicey has said, but A.V. Dicey still remains a very formidable front as far as what the rule of law is concerned. So let me summarize the discussion so far on rule of law by reminding you that the core elements that underpin the legal system. You remember that we mentioned that the elements are that we are looking at eradicating arbitrariness. We are saying that there must be equality, there must be respect for rights, there must be existence of an independent, incorruptible judicial system, there must be independent and courageous bar. Remember all those elements we are identified. Remember we mentioned 14 of them. That's Kofi Kumado identified in his book. Now I'll end this lecture by reading the summary of rule of law that was given by Hilaire Barnett in the book titled Understanding Public Law at page 47 of the report of the textbook. The moment you read this, if you have any doubts in your mind about what rule of law is, the confidence level should have been raised to a level that you can confidently now discuss what the rule of law is about. This is what the learned author says at page 47 of the book, and I quote, "The rule of law is a controversial concept that lends itself to several interpretations that reflect very different political arrangements. The Western liberal interpretation, the Marxist interpretation, and the traditional Oriental interpretation being just three. From the Western liberal standpoint, from the Western liberal perspective, law is a positive force in society, providing a framework for government under law and accountable to law, and the framework also for the maximization of individual freedom and rights within the law and protected by the courts. The rule of law also has a very practical application. The rule of law can act as a yardstick for measuring the extent to which the legal system complies with the concepts of legality and constitutionalism. The requirement of certainty in law underpins the idea that no one shall be punished except for a breach of law. The idea of equality before the law, so easily misunderstood, acts as a guide to the manner in which a legal system must be arranged to maximize access to law and the protection of the law. It also requires that those who hold special powers are accountable to the law, that no one, irrespective of rank and station, is above the law, and the quote ends. This brings us to the end of our lecture on the theoretical basis of the rule of law. In our next lecture on rule of law, we shall see how the concept has been applied in the case law. We'll look at the foreign decisions and we'll see how it has also been manifested in the Republic of Ghana. And we shall specifically refer to the preamble to the 1992 Constitution of Ghana, which affirms the applicability of the rule of law. Then we'll look at a number of cases that have affirmed the rule of law in foreign decisions. We'll look at associated provincial picture houses versus the Wensby Corporation, 1948, 1 King's Bench at page 223. We shall also look at Council of Civil Service Unions versus the Minister for the Civil Service in 1984, 2 All England reports at page 935. We shall look at a number of cases like Nate and Gatti, reported in 2010, Supreme Court of Ghana Law Reports, page 745. We shall examine Salabi and another versus Attorney General, 1922 Ghana Law Reports, and some other cases. Our next lecture shall be an interesting discussion on the rule of law. And this is where we will end today's lecture on the theoretical basis until we shall begin with the other aspects that deals with the exposition in the case law. So for purpose of today's lecture, we are drawing the curtains here on the theoretical basis of the rule of law.